Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk about the bankruptcy of the Roman Catholic Archdiocese of San Francisco. Several years ago, the California legislature passed and Governor Newsom signed into law the act which essentially suspended the statute of limitations for certain claims regarding inappropriate contact between adults and minors. I'll leave it at that. And as a result of that, shortly after that statute was passed and signed into law, California churches, California Catholic churches especially, were hit with a number of claims against their parishes. And of course, those parishes get passed up to the archdiocese, and ultimately it's the archdiocese that is sued. Now, we don't need to go into the underlying claims because that's not really at issue here, at least in this video. And I also think it's an inappropriate content topic for YouTube. I will say that I think the people who filed lawsuits had every reason to. However, I think there is going to be a great deal of difficulty since some of these claims are 30 years old. People who may have witnessed those things may already be dead. People who committed certain acts may already be dead or out of the ministry. There are a number of problems with a legislature extending the statute of limitations after it's passed, not the least of which is a problem with due process in that once you have a vested right to be free of a lawsuit, it doesn't seem fair or equitable to allow that to come back. So I don't know that that's been tested all the way up to the Supreme Court, and ultimately that might prove to be a saving grace for some of these churches. I would point out that if their employees committed acts that were unlawful, that they should, under the law, they should stand good for the damages that result from that. But here is the problem when you have 537 of these cases filed against you. And it's simply this: it costs way too much to defend them. The typical lawsuit in a case like this is going to pull in a partner-level attorney, at least one, and probably at least two associates. And each one of those people, the partner will be billing above $600 to $700 an hour. The associates will be billing somewhere between $200 and $500 an hour, particularly out in California where legal fees are quite high. One of the law firms representing the actual archdiocese in this case has lawyers that pull in their 8th year as an associate. In other words, not even a partner. They're pulling in $415,000. Well, the way you can pay somebody $415,000 is you go and you get it from somebody else, and that's essentially what they do. So the fees out there are going to be quite steep, and because of that, you can't defend all of these cases at once. The facts are different in every case. The actors are likely different in every case. The types of claims are going to have little warts on them here and there. There are all kinds of things that make these cases very defensible and hence worth spending the money on, assuming you have the money. When you get to the level where you have 537 of them and you're paying out $100,000 to $125,000 every 6 months in legal fees, that becomes simply unmanageable. And you have to defend every one, because if you get hit with a default judgment, if you don't defend a case, well, you're going to get stuck with a big judgment anyway. So that's what led to the filing of the case in bankruptcy. And they filed it under Chapter 11. Now, when I did my little spiel on bankruptcy, I mentioned Chapter 11 briefly, but I didn't go into it a great deal because, for the most part, it's very similar to the other bankruptcy procedures, but there are a few little wiggles in it that are quite different. One of those is that if you are a private plaintiff, or I'm sorry, One of those is one of those involves the situation where a person files individual bankruptcy, either under Chapter 7 or Chapter 13, and prior to the bankruptcy, they got into a fist fight and they beat someone and they hurt them very badly. Well, now they're being sued and they want to discharge that debt. There is a process under the bankruptcy code to deny someone a discharge for intentional wrongful conduct that harms another human being. And as a result of that, discharges can be denied for that reason, but not so with regard to corporate entities or Chapter 11 litigants. Now, I could go through all the statutory language and that kind of thing, but I'm not going to, because I've seen this happen firsthand in the Mallinckrodt bankruptcy. We had pretty good evidence of criminal conduct, and indeed the government had settled a False Claims Act case against Mallinckrodt, but we couldn't proceed against them for non-dischargeability because the statute did not allow it. And that, I think, is a grave injustice that's written into the bankruptcy code. But I'm not a senator or a congressman, and I can't do anything about it, and I don't look for Congress to do anything about it, even though there is always a great deal of hand-wringing about that, about the time that votes start being cast. To get to the point here, the process in bankruptcy is just a great deal different than what you would get in civil court. So when someone marches into California state court and they sue, they pay $300 or $400 to file their petition, and they pay $300 or $400 to get service of process on the archdiocese, and then their attorney starts collecting medical records and building up the evidence to bring their case. He does that because he knows that he's going to get a chance to put his case in front of a jury of 12 people. And 12 people would, I think, be pretty disgusted and very angry at the way that the claimants in those cases were treated. And as a result, it has a great deal of jury appeal, and there is a good chance that somebody could make a pretty good fee and the client could get a pretty good recovery in one of these cases. But there are a few things that come into play once bankruptcy is filed that really negate any good at all coming from individual plaintiffs. Let me explain why that is. First of all, the automatic stay kicks in. And the automatic stay says you don't file anything more in state court, you don't file any more cases in state court, have to bring everything to the bankruptcy court. So all these cases that are filed throughout the country against the Archdiocese of San Francisco will be brought in to bankruptcy court. The first thing that happens is you lose the right to a jury trial. In bankruptcy, the bankruptcy judge is the finder of fact and the ruler on the law, with a few notable exceptions. In addition to that, there is a situation where, well, let's take a case where the name of the person who committed bad acts is known to the plaintiff. And now, instead of being Father John Smith, he is just John Smith. In addition to suing the archdiocese, many times lawyers will sue the individual actor too, not so much because they expect to get a great deal of money out of that individual actor. More often, they intend to get admissions from that actor that, oh yeah, the archdiocese knew this was going on. So one of the things that happens in bankruptcy is if the archdiocese is the target, but they have indemnity agreements with their prior clergy. In other words, they say to them, you don't need to worry about any claims that are filed against you because we're going to defend and indemnify you. And as a result of that, this person gets sued, well, he now has a claim for indemnity against the corporation or the church. And as a result of that, the church will most likely seek an injunction and try and bring him within the ambit of the bankruptcy court and say that you can't proceed against him in state court, which is where his case would have remained. You have to bring that case into the bankruptcy court because it is a related case and it's directly related to the bankruptcy. So not only are you prohibited from going after the archdiocese in state court, you are prohibited against going after any of the other actors who were at one time an employee of the archdiocese, because they will pull them into bankruptcy court with them. And that's whether they have an indemnity agreement or not, because there will usually be vicarious liability for the archdiocese based on the fact that they were employees. So again, the bankruptcy jurisdiction is very broad, and it can be broadened with a number of procedural moves, and that's one of the things that makes bankruptcy such a difficult area of the law to work in. There can be jury trials held at the district court in certain instances, but in most cases, that's not the way claims are resolved. Now what's happened is, instead of having a lawsuit against the archdiocese, you have a claim against the archdiocese. So you fill out a claim form and you submit it to the bankruptcy court, and it's filed, and it's listed as a contingent liability, meaning that if the underlying case is deemed meritorious, you would be entitled to compensation through the bankruptcy system. And of course, the way that it would be determined in bankruptcy would be essentially a trial where evidence would be put on in front of one judge, and the court would determine whether there was a valid claim or there wasn't a valid claim. That's going to be a very difficult case to prove to one judge. And as a result, it's going to be very difficult, I think, for many of those claims to be successful unless, and this is the big unless they can get a global resolution and settlement. And that's what the aim of this really is. You aggregate all 537 of these cases. You decide what the average value of those cases is, and you work out some kind of settlement so that everybody gets something. The first thing, well, not the first thing, one of the first things that will happen is they will form what's called the Unsecured Creditors Committee. So there will be probably 3 or 4 big name law firms in California who are representing plaintiffs, and they will petition to be on the Unsecured Creditors Committee, sometimes called the UCC, not to be confused with the Uniform Commercial Code. The UCC is the body that represents the unsecured creditors in the bankruptcy. There is a Secured Creditors Committee. There can be other ad hoc committees formed as necessary. For example, there might very well be a committee representing the clergy in all of this to make sure that their retirement benefits, to the extent that they have retirement benefits, would be respected. There are all kinds of different things that happen inside of bankruptcy. Also, the U.S. trustee is part of the equation, but the U.S. trustee does not actually start running the company. That, or in this case, the church. In this case, the church will continue to be run by the clergy who are operating the archdiocese and all of the churches. And for the most part, business as usual will continue to go forward. And they will continue to pass the collection plate. They'll continue to do mission work. They will continue to do most of the work of the church. The only difference will be that they will not be out there in the state court defending all of these state court lawsuits. So eventually what will happen is you'll get a group of lawyers from one side to sit down with a group of lawyers from the other, and they will try to hash out some kind of deal that respects the rights of the claimants and hopefully that sort of filters out cases that are close to the edge, let's say. So I hope this is interesting. I hope you find this to be sort of a topical subject. There have been a lot of cases recently, especially one against President Trump in New York, that arose out of this extension of the statute of limitations. And this is one of the results of extending the statute of limitations. You drive certain entities into bankruptcy. That's what I have for you today. Thank you so much for watching. If you have the opportunity today, reach out and do a kindness for someone. We talked the other day about planting a tree, but that's by far one of the simpler things you could do. Go to the nursing home and read the Bible to the people who are in the nursing home, or read a book to someone in the nursing home. Volunteer at your child's school to come in and be a reader, particularly if you have somebody in the 1st through 3rd grades or 1st through 4th grades. A lot of times there are schools where they will bring in the parents, and the parent gets to read a book to the children that parent really likes. And that makes a big difference to the children, and it's entertaining to the adult, and it's just a win-win all around. And it proves to your children how much you value the skill of reading, as well as the value of public service. So you might want to think about that. Be kind to one another, and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.